Hi there. Thank you so much for taking your time out of the day to join me and learn a little bit about your workplace rights. My name is Colette Mahan, and I'm an employment law attorney with Greenberg Law. I absolutely love my job. I'm a trial attorney who fights for employees' rights. I work on a lot of disability discrimination cases, failure to accommodate disabilities, retaliation for taking medical leave, as well as gender discrimination and unequal pay cases. I love fighting for my clients who were loyal, dedicated, hardworking employees who were working for employers who skirted the law and took away their livelihood, and in many cases, their second families. I created this webinar to educate employees about their workplace health rights because over my career, I've realized how little people know about these rights. And with a major expansion that went into effect in California, January of this year, 2021, it's even more important to learn about these rights and protections. So I want to equip you with, so that if you ever have a health condition that requires some time off or time off to care for someone else, or you have a disability that may need an accommodation, you'll know how your job is protected in the meantime. You should be able to maintain your health and your job. And that's the purpose of these laws, to ensure your employers do just that. So this is a broad overview of some of the main laws that provide these workplace health protections. So it's important to speak with an employment attorney if you have any specific questions related to your own case, because every person and their situation is very unique. And this area of the law is complex. It's very fact intensive. So here you can gain a general understanding of your rights. But again, it's best if you reach out to an attorney to ensure you've got your bases covered. And many employment law attorneys will provide free advice to hopefully prevent any adverse action taken by your employer in the future. So you may not think you'll ever need these protections, but you just can't know what the future holds. You know, one thing is for certain, we will all get old, our parents and loved ones will all age too. And with that typically comes illnesses, medical conditions, surgeries, and the related recoveries. Also, the unexpected could certainly happen, such as an accident. So these laws have provided protections to many of us already, and will touch many others in the future. In the summer of 2013, the unexpected happened to me when I was in a really severe car accident, and I had a long recovery. My father was able to take time off without fearing for his job. He was protected. You should be able to keep your health and your loved one's health as your number one priority without fearing for your job. Many things in life we just don't have full control over. And when health issues arise, most of that is just out of our control. Now, couple this with the loss of control when you work for someone else. And many of us do. I represented a woman with a medical condition, and she couldn't control it, of course. She couldn't control when or how often or how intense it was. Sometimes she came sometimes the condition came on at work or at home, and she needed to call in late, or she needed to leave early, take a partial day off, right? Or she just simply needed to work from home that day. Her superiors grew increasingly frustrated and annoyed, and they started citing these workplace policies that employees could not work from home anymore. You know, she was calling in late past her start time, and she could no longer take a partial day. She just had to take the full day off. Finally, my client pushed back, questioning why they couldn't accommodate her, and she was terminated. Unfortunately, her workplace did everything wrong when given the chance to correct things. It did not listen to her concerns. It just did not want to accommodate. Nobody told my client about her right to intermittent leave, which we will talk about. Nobody told her about her accommodation rights, which we'll talk about. So you may be thrust into something that's out of your control, the sickness, injury, medical condition, and these laws give you a little bit of control back. And as we've seen in the example, not all HR employers understand these laws and will let you know what your rights are. The purpose of the laws is so you don't have to choose between your health and your job. And if necessary, you will need to educate your employer and you will need to insert these rights. You should also understand how you can stay within the protections of the law. Preparing to take a leave for yourself or for a loved one is just already really stressful, and you're already in a really vulnerable time. So, an employer who says we don't have a job for you when you get back, or we can't accommodate you, is just the last thing you want to face. And you may not know where to start because this law is confusing and it is complex. And you just may be nervous for simply asking for telling them you need this upcoming time off because you didn't plan to get sick or injured or wear down your body. And you certainly can't plan when that happens to a loved one. As we and our loved ones age, we just start collecting one ailment after another. And while you can't prepare for what ailment will get added to your collection, you can definitely prepare for how it affects your job. So today we're going to learn about taking protected medical leave for yourself and others and what it means to be protected. And we'll learn about how you can ensure you remain eligible for certain protections. And after discussing medical leave rights, you'll also learn about your employer's duty to accommodate your disability and not discriminate against you for your disability. You'll come out of this with the confidence and knowledge that your employer can't deny you or interfere with your ability to use this leave or retaliate against you, of course, for taking this leave or simply asking for it. And it cannot discriminate against you for having that disability or needing an accommodation for a disability. Handling your health is scary and comes with many unknowns. So while you're already, physically, emotionally vulnerable, you shouldn't have to worry about your job too. So let's dive in. The California Family Rights Act, known as the CFRA, which is what I will be referring to throughout the presentation, is similar to the federal law, the Family and Medical Leave Act, also known as the FMLA, which a lot of us have heard of. This law is what provides your ability to take family and medical leave. So let's first cover who is eligible. There's a work time requirement for you and an employee threshold for that subjects employers to this law. So you must have worked at least 12 months and at least 1,250 hours the previous 12-month period. You are eligible for this leave if you work for a company that employs 5 or more employees, that part or full-time. And that's a substantial and recent change that went into effect January of this year. Because prior to then, only those employed by employers with 50 or more employees were eligible for CFRA leave. So it went from 50 to just 5. This is a huge expansion, and a lot of new employees are now eligible for this leave. So let's talk about the qualifying reasons for this leave. Your own serious health condition. You can take leave for your own health condition, except this leave does not cover leave for disability related to a childbirth or pregnancy. That is covered under a separate statute that provides for such leave. The health condition must make you unable to perform the essential functions of your job. And that is determined through a myriad of factors that the law has laid out. You can also take this leave for after the birth of your child or placement of a child in a connection with an adoption or foster care to bond. This is bonding leave. And it's great because both parents can take bonding leave, and that's even if they work for the same employer. You can also take this leave for reasons related to the deployment or military activities of your spouse, domestic partner, child, or parent who is a member of the armed forces. And you can take this leave to care for the serious conditions of others. Being with family is, when they need it the most, is extremely important. And the law recognizes this. That's why this leave is not just limited to caring for your own health condition. There's been a major expansion to this list that went into effect in January 2021. So it includes parent, spouse, registered domestic partner, a child of any age, siblings, grandparents, and grandchildren. So, what are some more requirements for the health condition? The health condition must make you unable to perform the essential functions of your job. Hence, this is why you need to take this time off. It must also include inpatient care or continuing treatment or supervision. Inpatient care simply means a stay in a hospital, a hospice, residential care facility, and any subsequent treatment in connection with that stay or care, and any period of incapacity. And incapacity means you're just unable to work or go to school or perform daily activities because of the condition. Continuing treatment means ongoing medical treatment or supervision by a healthcare provider. And this leave, the length of leave, this leave you can take up to 12 weeks in any 12-month period. Now, what if you need to take more than 12 weeks? California's Fair Employment and Housing Act, otherwise known as FEHA, may require your employer to provide you with a finite leave of absence, which could be longer than 12 weeks, as a reasonable accommodation for a disability. And we'll get into reasonable accommodations for disabilities in just a bit. If you do need more than 12 weeks, for example, 16 or 20 weeks, you would no longer have the protections that the CFRA provides, though. So it's important that you understand that so that you can talk to and work with your doctor in deciding whether or not you really need the additional time off. Say it's just 1 week, 2 weeks, something like that. I'll talk more about the protections you have with the CFRA if you only take 12 weeks or less versus taking a longer leave of absence for a disability, because there are certain protections that go along with that. So how can you kind of take this leave? So in addition to taking a kind of straight leave of absence, that is a consecutive period of time shown here, you can also take intermittent or reduced schedule leave. Intermittent leave is taken in separate blocks of time due to a single qualifying reason. For example, you have a chronic migraine condition and you sometimes need to come in late to work, or sometimes you need to just leave early because you're having an episode's coming up. So you should request intermittent leave so you can use that for the time that you need to care for your condition when it comes up. Reduced schedule leave. So this leave is a change in your schedule for a certain period of time. That's kind of shown here. And it's usually from full-time to part-time. For example, you may have a condition that you're recovering from, but you can't exert yourself full-time just yet. So you can request reduced schedule leave to kind of help manage your fatigue and your recovery. So when do you notify your employer of your need for leave? There are laws regarding this. Let's talk about emergency. That is, just comes up, you didn't know what's going to happen. So when this happens, you must provide notice as soon as practicable. This is simply as soon as you know you need leave, you should tell your employer. Foreseeable. This is when you have an idea it's coming up. You must provide your employer with reasonable advanced notice of your need for leave. And this means, telling them within a reasonable amount of time after you learn you'll need this leave for yourself or someone else. There are no hard time limits here, so it's just all about acting reasonably. For the third one, planned, this is if you have medical treatment or you're needing to supervise someone else that's already planned out. Your employer can require you to provide 30 days advance notice. And if you're not able to provide that 30 days advance notice for some reason, again, it's simply, provide it as soon as you're able to, as soon as you know. Another thing to note is that you must also make reasonable efforts to schedule the treatment or supervision of someone else to avoid disrupting your employer's operations. Of course, this needs to be approved by the healthcare provider. And it's extremely important to know and understand that you are not required to tell your employer what serious health condition is involved when requesting leave. Again, you are not required to tell your employer what serious health condition is involved when requesting this leave. It's simply 4 things. You need to take leave, the reason you need to take leave, for example, my own serious health condition or serious health condition of someone else, when you need the leave, and how long you anticipate you need the leave for. So again, when you tell your employer the reason you need leave, you don't need to tell them what the serious, the underlying health condition is involved. Now, your employer may require you provide a medical certification from your healthcare provider or the healthcare provider of the individual you're caring for. Don't worry, again, this form does not include questions about what the underlying condition is. So again, you can keep this confidential. Now, an employer can ask for a second opinion, but only if they have reason to doubt the validity of the first. And if that second opinion differs from the first, then your employer can require a third, but that third opinion will be considered final. And just to note, a second or third opinion is not required when you need leave to care for someone else. Now let's talk about those protections. Return to work rights. There are certain job protections I talked about that this CFRA leave provides you if you take leave for 12 weeks or less. And again, these protections won't apply if you take longer than 12 weeks. When you return to work, you must be returned to the same or virtually identical position to your former position. And what is virtually identical is a fact-intensive question because there are just many factors that are considered. They include looking at duties, responsibilities, pay, your shift, your schedule, the geographic location, the privileges. There's a lot. Again, fact-intensive here. It's really important to understand and know that you are entitled to reinstatement here, same or virtually identical position, even if you have been replaced or your position has been restructured to accommodate your absence. And that happens a lot while you're out. So example, to accommodate your absence, your employer divided your duties between the remaining employees. Your employer, if that happens, your employer can't say, we're not going to reinstate you to your old position because it's just going to continue with the way, the restructured job duties. They can't do that. But there are certain exceptions to reinstatement. So let's talk about that. Your employer may not be required to reinstate you if they prove that had you continuously been employed during the time that you took leave, your employment still would have ceased or your hours would have otherwise been reduced. So had you stayed employed and you didn't take this leave, they were still going to terminate you or reduce your hours. And sometimes the employers try to prove this by arguing that you were replaced, or your job was restructured to accommodate the absence. But again, that's not going to satisfy this burden. So what could this look like? One example is your employer had already planned a restructuring, or your employer had already planned, they were going to do a reduction in force or a RIF. Even if you had not gone on leave, that would have applied to you. It would have terminated you or restructured your position. Another example, for the exception to reinstatement could be if your employer found out you violated some company policy while you were on leave. And so even if you hadn't taken leave, they would have decided to terminate you because of the violation. Some more protections. Your employer cannot discriminate or retaliate against you for taking or discharge or suspend you because you exercise this right to take this leave. Now, some other examples of adverse employment actions that could constitute illegal discrimination is this long list: demotion, suspension, denial or reduction of bonuses, unequal pay compared to those who didn't take leave, reassigning your duties, taking away supervisory responsibilities, poor performance reviews, denying training, being assigned to lower visibility projects, heightening scrutiny of your work, undermining or sabotaging your work, assigning you more work than your peers, relocating you to a less desirable job site, repeated harassment, being left out of team meetings, events, lunches, scheduling your hours abusively, threatening you or a family member with an immigration action such as deportation, belittling you in the media, delaying your return to work after leave, taking away previously held privileges, and any conduct likely to impair your job performance or ability to promote. Again, these could be adverse employment actions, and this list is not exhaustive. It's important to talk to an employment law attorney if you think you've suffered discrimination or retaliation. And your employer can interfere with your exercise or attempt to exercise your right to take this leave. Anything that your employer does to interfere with your ability to take leave is impermissible. So this could include discouraging you in the first place from taking leave, failing to guarantee your job upon your return, or denying you this leave. And other examples could be requiring you to exhaust vacation time before approving CFRA leave, or getting write-ups for taking too much time off. So this is, of course, again, not an exhaustive list, just a few examples of what may amount to illegal interference. Pitfall to avoid here is taking that leave more than the 12 weeks. So if you take leave for 1 day over 12 weeks, you lose your right to reinstatement. You're no longer within the protections of the CFRA. I had a case where the doctor put my client on leave for what they thought was the full duration of the FMLA or CFRA. Instead of counting 12 weeks, they counted 3 months. And my client's return was over 12 weeks. It's just past that 12-week mark. So she no longer had those clear-cut protections to, getting reinstatement that this law provides and putting her back into the same or virtually identical position. But so super important if you've been feeling, well, what else can I do if I need longer than 12 weeks? My client did have other protections as she was out on leave for her own disability. So her employer was then required to accommodate her disability, and that can include a longer leave of absence. So this is a great segue into accommodation rates, because under the law of reasonable accommodations, you may be able to take leave for longer than 12 weeks and still have a job to return to. The California Fair Employment and Housing Act, FEHA, prohibits employment discrimination on the basis of a disability or a medical condition, and requires that employers provide reasonable accommodations to employees with a disability. Now, California actually provides broader protections than those provided by the federal law, the Americans with Disabilities Act, the ADA, which it was modeled in Part 1. Your employer must provide you with a reasonable accommodation if it employs 5 or more employees. So this is the same kind of employee threshold now as the CFRA. And your employer is required to provide you with, modifications or adjustments that enable you to perform the essential functions of your job or the job you applied for. And these are just a couple examples of, what reasonable accommodations may look like, what these adjustments may look like. Making facilities accessible, allowing assistive animals, transferring you to a more accessible work site, providing assistive aids, restructuring your job, providing part-time or a modified schedule, altering when or how an essential function is performed, modifying exams, modifying policies, modifying supervisory methods, providing more training, permitting an employee to work from home, providing paid or unpaid leave, which my client got, and providing reassignment to a vacant position. Now, we've talked about this one a little bit earlier. If you have the disability that requires, say, 4 months or 5 months of leave, and you don't have the reinstatement rights that we talked about under the CFRA, that is, returning to the same or virtually identical position. But if you take that longer leave, your employer could argue that permitting you to take 4 or 5 months of leave would cause an undue hardship. So it opens you up to this defense they have. It's too long. They need to replace you. It's causing an undue hardship. Throughout the interactive process, which I will describe shortly, you and your employer should be identifying an accommodation that would enable you to continue performing your essential functions while not causing this undue hardship on the employer. Your employer must prove that the accommodation, which could be a leave of absence, would create an undue hardship because it would be significantly difficult or expensive. And there are a myriad of factors to consider in order to make that determination. So the nature and cost of the accommodation, the ability of your employer to even pay for that accommodation. The type of operations conducted are considered, the impact on the operations as well. What's also is considered is the number of employees and the relationships of their duties to one another. So it's a really multifaceted, fact-intensive inquiry. And if you believe your employer's decision not to accommodate you is unfair, it's really important to speak to an employment law attorney about your specific situation so you can decide what next steps to take. Let's talk about the health conditions covered under this law, the FEHA. So physical disability, the law actually has a list there, kind of what you would think: deafness, blindness, an impairment requiring the use of a wheelchair, and a few others. It's non-exhaustive. So essentially, here's a test you have. Do you have any type of anatomical loss, cosmetic disfigurement, physiological disease, disorder, or condition? And does it affect one or more of these body systems? And lastly, this is the most important one right here. Essentially, does the condition make achieving a major life activity difficult? Again, does this condition you have make achieving a major life activity difficult? Simply, if yes to all three, then you're covered. This law also includes mental disabilities. Again, the law provides another non-exhaustive list, and it includes schizophrenia, chronic and episodic conditions such as clinical depression, bipolar disorder, PTSD, emotional or mental illness, and more. It also includes special education disability. So any health impairment or mental or physiological disorder that requires special education or related services. Disabilities also include if you have a record or history of a disability and you're being discriminated against on that basis. So if you're also covered if your employer is just aware you had a record or history of a disability, and you're also covered if your employer just perceives you and treats you as if you have a disability, even if you don't. So definitely important to know too. Even if you don't have a disability, but your employer believes you do or just regards you, treats you as having one, and they're discriminating you on that basis, this law will provide you protections. And lastly, it provides protections for those with medical conditions. And the law defines that as cancer. And it also includes genetic characteristics. So a disease or disorder caused by a gene or chromosome or an inherited characteristic in your offspring. That could be genes known to cause breast cancer, Down syndrome, and more. Now let's talk about interactive process, and I alluded to this before. It's extremely important. We all understand the body is really complex. We like to think we have it figured out, but truthfully, we don't, and we're still learning. So when you need an accommodation at work, some employers learn what your medical condition is, and they just slap their own preconceived, ideas on how that condition presents in you. They'll make assumptions about your limitations and the ability to perform your job. Instead of finding out from you what your limitations are, they take what they know from families or friends who've suffered the same condition and just apply that to you. So once your employer is aware you may need an accommodation, your employer must engage in a timely, good faith, interactive process with you to determine an effective accommodation. This process should involve speaking with you about your job responsibilities, discussing possible modifications so that you can continue working while maintaining your health at the same time. And you're in the best position to know whether your medical condition is restricting your ability to do your job. And if it is, what accommodation would be effective in enabling you to get your work done. Do not let your employer get away with some blanket refusal to accommodate. No dialogue, nothing, no questions, no interaction. Ask them, what are your concerns? Ask them, what options have you considered? Ask them to get it in writing. You may have to advocate for your job here, and you may have to force the conversation. Invite the collaboration. Provide creative solutions. I mean, there may just be misunderstandings. There may just be misconceptions on what your limitations really are. So if you learn what their concerns are, you may be able to clarify the restrictions your doctor placed on you. You may want to ask your doctor to help clarify or even adjust the requests. In many cases, your employer just looks at that list of restrictions from your doctor and they never ask follow-up questions and just make a decision without you. And they don't even ask you questions or the doctor. They may make these decisions by misinterpreting and the restrictions and your job and your requirements. So here's a little anecdote. This is what your employer says. You should take some more time to heal. You're trying to come back from leave, right? But I can do my job. Let's just give it a little bit more time. It'll be better for you to get back to 100%. You're not quite there, right? We have a couple of these restrictions, but I can do my job. You have too many restrictions. We can't accommodate, but I know my job best and I know I can work around this and we just can't accommodate you. We want you at 100%. What just happened here? Something doesn't feel right, feels unfair. The employer did nothing to understand the employee's needs and why they believed they could do their job, even though they had some of these restrictions. May not even have applied to the job. This is just totally unacceptable. And an employer is required to engage in an interactive dialogue to determine the accommodations. Here, there was no dialogue, no Q&A. There's just no solutions at all. And unfortunately, your employer likely won't ask you all of the right questions to get down to whether it can accommodate you and whether you'll be able to perform your job. So you're essentially left to advocate for yourself. And you can do this. You can explain, these are my specific needs, find out your employer's concerns, propose solutions so you can get back to work, and keep the dialogue open. And it's important to keep that dialogue open because a couple pitfalls to avoid here. Under the law, you cannot be the cause of a breakdown in communication. So during this interactive process, you must ensure you're not the cause of the breakdown. You need to continue to reach out to the employer after you've made your accommodation requests. Ask for updates. Ask them if they need more information from you or from your physician. Just repeatedly go after them. You do not want to be the one on that side, causing that breakdown. The other pitfall to avoid is, the indefinite versus the finite leave. An indefinite leave is one in which you tell your employer, I need time off, but I'm not quite sure how long the recovery will be or when I'll be back. And then opposite, a finite leave is, I need this much time off and it's a certain amount of time. So if your doctor informs your work, you need leave, but it is for this indefinite amount of time, your employer may now have an excuse to refuse to accommodate because they could argue providing some indefinite leave, we don't know when the employee will be back, 4 months, 5 months, 6 months, 8 months, we just don't know when. That would cause this undue hardship. You could be out for months, right? So it's better to have your doctor provide a finite period of leave and then ask for extensions as needed, right? This will give you a better chance of avoiding some argument that this leave is an undue hardship because it's this indefinite period of time. And again, there are some exceptions to this law too. So one would be, you must be able to perform your essential duties with or without accommodations. If you can't, your employer can terminate you or refuse to hire you. So when you're going through this interactive process, trying to determine accommodations, and they find that one, they just don't have any way to accommodate this, or it would be an undue hardship, this is an exception from this rule. They don't have to provide that accommodation. The second is the health and safety. Your employer can refuse to hire you or terminate you if you can't perform your essential duties without endangering your own health or safety or the health and safety of others, even if your employer provides some reasonable accommodation. So again, it's important to find out, what are the concerns specifically? Why are they denying it? Is this health and safety thing? Like, talk it through, get it in writing, Some more protections similar to the CFRA. Your employer cannot discriminate against you based on your disability or medical condition. And as we identified earlier, there's a list of adverse employment actions that could constitute illegal discrimination. And your employer cannot retaliate against you for trying to exercise your rights, including just asking for an accommodation or complaining about some violation of your rights, or filing a formal complaint too. And they cannot retaliate against you for helping or assisting and testifying in any proceeding to vindicate rights under this law. Lastly, your employer and any person, including your supervisor or an HR employee, they are prohibited from harassing you on the basis of your disability or medical condition. And your employer may even be responsible for non-employees who harass you if it knows or has reason to know of that harassment and fail to take immediate and appropriate action. And lastly, seems logical, your employer must take all reasonable steps to prevent discrimination or harassment from occurring. So I just want to thank you so much for spending some time with me and learning about your workplace health rights. I really hope you were able to take away a few gold nuggets and have the confidence and knowledge that you can take time off to care for yourself or for a loved one without being fearful of losing your job. So take care and good luck.